Appeals of Tennessee is now in session.
Good afternoon and welcome to the afternoon session of the Court of Appeals. The panel today will consist of Judge McGee, Judge Armstrong, and I'm Judge Golden. Madam Clerk, would you please call the next case?
In Re Arianna B et al.
We'll call for the appellant to
Yes, Judge. I'm Casey Brown. I represent the appellant in the case, Mr. Corey Brandenburg. We're here on a appeal of the termination of parental rights, and or issues that we bring up is, whether the trial court erred in granting the appellee's petition for the termination of parental rights by finding they proved by clear and convincing evidence the appellant abandoned the children by willful failure to pay support during the relevant time period prior to his incarceration. Second issue that we have is whether it was in the best interest of the child, and the third is, did the trial court err in not allowing a witness to testify in that? And for the first issue that we have, for the non-support for the 4 months, we would say that the trial court did not prove by clear and convincing evidence that he willfully non-supported the child during that time. The time period that they had for the non-support was June 2018 to September of 2018. During that operative 4-month period that the court chose to use, the appellant was still married to the appellee at that time up until August, which we would argue that there was no support required in that time. There was no support set out during that time. The divorce didn't occur to August for that. Further, the appellees entered a final decree into the proof in this case. That final decree waived any support for that 4 month up until December of 2018. So we would say that was kind of, we don't know how you would pay something if that was waived and there was no support order down. So we would argue that he did not willfully non-pay during that time, that there was no requirement for him to pay at the time.
Mr. Brown, is that some sort of typo with regard to that retroactive date? Because part of that date is post-parenting plan, so it wouldn't be retroactive.
It would be, from what my understanding is, it was until December of 2018. I think the reason they went for that 4-month operative period was that he was incarcerated at some time after that.
Okay. Now, but the actual parenting plan order doesn't say his child support is to start like in January of 2019, does it?
I'm not sure on that.
Okay. Go right ahead.
Okay. Also, during the trial in June that they had on this, I think there was testimony of Mr. Brandenburg, the appellant in this case, that he offered money at times and that it was refused to wasn't accepted. They refused to accept at that time that he had offered mother some type of payment. I think even after that, his mother had offered part of a tax refund to pay the grandmother of the appellee, the mother of the appellee, everything. So for those reasons, we would submit that there was no willful non-payment of that.
Mr. Brown?
Yes.
So are you saying that an attempted payment from one grandmother to another grandmother is what you're alleging to be payment of child support?
Well, I'm saying that it wasn't willful non-payment, that they attempted. He was in jail at the time and couldn't make a payment, but I believe his mother reached out and was trying to make a payment at some point. And that a payment was refused, that she asked for a receipt. They would not give him that receipt and everything. And she didn't want to pay it. And then there'd be no proof of it. So we would say that would be that he did offer up payment and tried to, that it was not willful non-payment.
And that's in the record?
That it does. I think our brief supports that there was testimony of the record that says that the grandma had tried to pay at some point with a tax refund while he was incarcerated.
And that proof was offered to the trial court?
Yes.
All right, thank you.
As far as the second prong of our argument is the best interest, when we get into the best interest argument, the guardian ad litem in this case couldn't determine she couldn't make an argument for it being in the best interest of the child to terminate. She kind of deferred it to the court. I think in the transcript of that, she said that, you know, this was a really close one, that she couldn't see it was in the best interest for the child not to be in, for the termination to occur. I think the appellees in their petition alleged that there was, they talk about the relationship of the child. I think the court even goes into one point saying that it would be tough to disrupt the child's life by doing it now, but we weren't really asking for that. We were just asking to reestablish the relationship. The father had a relationship with the child up until the time of the divorce. So yeah, I believe it was around 7, the oldest daughter, when they divorced. So he had plenty of a connection with the child. He testified in the trial court about riding 4-wheelers, taking the child to school every morning and stuff like that. So there was a relationship there. The divorce is what stopped the relationship. So once the divorce occurred, she kind of cut communication off with him. There was some stuff in the, there was some allegations about some supervised visitation, where there was one incident. The judge really never made a finding of credibility on which side, because there was differing testimony from the appellant and the appellee during that. The appellant, though, did try to have visitation. He had contacted, when he was released from jail, he had contacted the mother. He testified to that in the case. He had, I think he testified as soon as he got out of jail, he had messaged the mother. The mother had blocked him. And I think the mother testified that she had blocked him at some point, and she blocked him on some social media. She couldn't remember exactly what social media she had blocked him on, because of the, I guess, the kind of anger-filled rants they had and stuff like that. There was not a good relationship at that point. Of course, with many divorces, there is not. But
Mr. Brown,
yes.
You're saying that she allegedly blocked him on some social media. Was that after the petition to terminate was filed?
I believe it was before. I can't remember exactly, but there was allegations in the trial. There was testimony that she had blocked him at some point. They were not having a good relationship, so she had blocked his number. She had blocked him on some forms of social media, but not others. And she couldn't remember. I know Facebook is the one that I was about to testify to, or about to lead up to, that he had messaged her on Facebook. She couldn't remember if she had blocked him on that or not. She knew she had on Snapchat and some other forms, though.
Well, I'm just trying to clarify, because I believe you stated that it was after he got out of jail.
I believe that is correct. And I don't know if she had blocked him before or after that, but I know when he was out of jail, he tried to contact her, and I believe that was in June of 2019.
All right.
So he tried to contact her at different points. He had 2 motions as far as going for the best interest. He had 2 motions for visitation. He had filed one with his petition for modification. It was pretty much ignored by the other party in the case. There was a ruling on it. Then there was another motion later on that the appellees moved to quash. So as far as abandonment goes in best interest, I think it shows that he tried to maintain visitation with his child. He tried to have that relationship with his child. He admitted at times that he was in a bad place, but he still tried to contact the child. Children try to keep that some kind of relationship with him at that point. Since he's been released from jail the last time, he's working now, and I think all this was put on at trial too. As far as best interest goes, that he now has a place that is good. He's got a home, kitchen, 2 bedrooms. He has a place that's suitable for children. He's been working. He can show a work history that he's had that he may have not had in the previous times. I think he's making, I can't remember the exact amount. I apologize for that, but I think it was like $14.25 an hour that he's making now. He's working 40 hours a week. This was at the trial in June, I believe, and it was for 3 months before that he'd had that job. He had showed a history of having 2 other jobs, full-time, working 40+ hours during that time. Also, his mother testified at the trial that she had seen a complete 180 in him. That they had a kind of a contentious relationship for a little while, and he wasn't even he wasn't even allowed to be at her house there for a period of time. But now he's done a complete 180. He's doing very well. And she wishes that for the court to be able to award him to be able to see the children and stuff. The third issue we had was about a witness not being allowed to testify. We just would say that would not be prejudicial or anything to him, to any of the parties, because the only parties that was deposed in this case would have been the main parties. There's no other witnesses that were deposed, and they weren't with this. And this witness that was wanting to testify was just testifying as far as to say that he saw a change, and it was the stepfather of the appellant, that he saw a change in the appellant during this time. And pretty much what we're asking for is for this petition to be dismissed. I'm sorry, for this petition for termination to be dismissed, and the petition for modification be remanded to the court for consideration on that.
All right, thank you. You'll have your rebuttal time. We'll hear from the appellee.
Good afternoon. May it please the court. My name is Dana Looper, and I'm here on behalf of the appellees, the Hammonds, or more specifically, the mother and the stepfather. This is the case heard too often in Tennessee: a parent inflicting domestic violence, abusing alcohol and drugs, and attempting suicide. A parent putting his needs above his children's needs. The children who bear witness to these events perpetrated by a parent are often the ones who suffer the most. Here, the mother finally broke free from the violence and filed for divorce. The parties agreed to a parenting plan that gave the father supervised visitation only. The parties signed this parenting plan in July of 2018, and they were divorced on August the 31st of 2018. The father agreed to the 8 total supervised hours a week with his kids, and this supervision was to be done by either his father or his mother or the mother's mother. The parenting plan signed by the father and entered by the court also ordered that child support be paid in the amount of $300 a month. At the time of the filing of the termination petition, father had been in jail between October the 12th of 2018 and June 18th of 2019. Therefore, the court reviewed the 4 months prior to his incarceration. The mother and stepfather alleged abandonment by failure to support and or visit, and that the father failed to manifest an ability and willingness to assume legal and physical custody of the children, and that placing the child in the father's legal and physical custody would pose a substantial risk of harm to their physical and psychological welfare. The trial court heard from the children's mother that she never received any support from their father. The father admitted he never paid any support to the mother. There is nothing found in the record that the father gave toys, clothes, medical supplies, anything for that matter to these children to support these kids. The father had the ability to work, and the record shows his employment history. Father's sole excuse for not paying his support said he didn't know where to send it. However, father testified that the children's maternal grandmother said that he owed $900 before his first incarceration. He knew where she lived and both mother and grandmother's phone number. Neither phone number changed, and that was testified to at court. Further, his mother testified he didn't pay support at first. It is well settled in Tennessee that biological parents must support their children, and this duty exists regardless of a court order or even if the parents are married. The record shows that the father had the capacity to pay support, did not do so, and had no justification for not doing so. The trial court properly concluded that there was evidence amounting to the high, clear, and convincing standard that the father abandoned his children by failing to support them. The father admitted during testimony that he did not pay support during the 4-month period prior to his incarceration. The trial court found that he had been working at various places and that he had been working during and after the marriage, that he doesn't have a disability that prevents him from being able to work, and that his choice to pay or to not pay was willful. The trial court order stated that the credible testimony is that the father started paying child support after the petition was filed. The trial court correctly did not consider these acts, as the father cannot repent his abandonment. The father abandoned his children by failing to visit them. Regrettably, the trial court only found this by a preponderance of the evidence standard. I know this doesn't amount to the requirement of clear and convincing evidence, but I'm also aware that this is a de novo review, and there's ample evidence sufficient in the record for this court to determine that that should have been found by clear and convincing evidence. The trial court found that the mother and the stepfather's testimony was more credible because the father had not seen or been around the children for so long. Mother and her mother testified that the last time the father visited with these kids was in May of 2018. The event is easily recalled because of the domestic violence incident that ensued. Father's testimony regarding this last visit with the kids is unclear. Father claims that mother was the last one to supervise these visits, yet this is the same mother who sought orders of protection and was granted a 5-year order of protection against the father. He admitted to searching for them after his incarceration, but this was only after he'd found out that a petition for termination of parental rights had been filed. The trial court should have found that the father's failure to visit was willful. He claims the only barrier to seeing these kids is the request for visitation was met with a request for child support. He nevertheless had the duty to make every reasonable effort to arrange and insist on visitation. Father didn't go to doctor's appointments or school events. Father didn't introduce any filings where he sought enforcement of the visitation order, even though his mother maintained a relationship with these children and saw them on occasions. This court may find willful failure to visit, and the record is sufficient to show that he abandoned his children by clear and convincing evidence. Further, the father failed to manifest an ability and willingness to assume legal and physical custody of the children, and placing the child in the father's legal and physical custody would pose a risk of substantial harm to the physical and psychological welfare of the children. The trial court did not rule on this issue, but it was pled by the petitioners. Again, I feel like the record is sufficient and properly on the record for you all to determine that this was also to be found by clear and convincing evidence. Placing the children in his custody would pose a substantial harm that rises to the level of a real and danger hazard. These children do not know this man. They are not bonded with they are bonded with their stepfather. The child's counselor diagnosed her with PTSD from the trauma ensued by her father. Putting these children in with the father would be a real danger and a real hazard to their well-being. The record was full of testimony about domestic violence, drug use, criminal history, and suicidal attempts. Father has taken no actions, no steps to show that he has rehabilitated himself. He has checked himself out of a mental health facility after a week's stay. He continued testing positive for drugs after jail, and the mother had to seek an order of protection that was later extended. The trial court failed to mention this ground of the failure to manifest a willingness pled by the petitioners, even though there's ample evidence on the ground of this on the record. The trial court properly determined that the termination of parental rights was in the children's best interests. Factors considered must be proven by preponderance of the evidence standard. Once there's been factual findings, the trial court should consider the combined weight of those facts to determine clear and convincing evidence. Best interests are viewed from a child's perspective rather than the parents. At the time the petition was filed, the legislature has codified certain factors in ascertaining best interests of the child. Those are different than the ones that are on today. This court has frequently and recently held that whether a meaningful relationship exists between the parent and child is the most important factor and carries the most weight. The trial court properly found that the father did not have a meaningful relationship with the children and that termination was in their best interest. The father has not been around the children in a long time. The stepfather has been performing the role of father. He's the one that's been bathing them, taking them to sporting events, coaching, to school, etc. The trial court found him to be very credible. It was after a threat of calling the police during a domestic incident that the father stopped coming to visitation. It was not reachable by phone. The guardian ad litem questioned the mother and the father about arguments in front of the children and his actions in their presence. She asked questions about the domestic violence and the child's nightmares, indicating these were important points that the trial court should consider. The guardian ad litem argued that she didn't believe a bond existed between the children and the father. There is a common sense notion that a parental incarceration is a strong indicator that there may be problems in the home that threaten the welfare of the child. Incarceration severely compromises a parent's ability to perform his parental duties. Father's proclivity for going to jail, mental health, substance abuses are certainly relevant for considering best interests. In summary, this court should affirm the trial court's ruling that clear and convincing evidence exists that the father has abandoned his child by failing to support them, and that termination of the father's parental rights are in the children's best interests. Thank you.
Let me ask you, that provision in the parenting plan where you waived support through December of 2018, is that a typo?
Your Honor, I do believe it is. And as lawyers, when we're preparing the initial pleadings for divorce, we type out a parenting plan And then we submit that with that initial filing. I believe that that was typed in there in the event that the parties were able to work out an agreement. And retroactive support only means that the support that's owed up until the date once an order is entered. I do truly believe that that was typographical error, and had it been a true issue, I believe that that would have been fleshed out at the trial court level.
What about, what was your client's testimony about this offer of the tax refund to be paid towards support? Was that actually offered by the father's mother?
So my memory from the record, I believe that the father had testified that he had tried to give the tax return while he was in jail to his mother to then give to the mother, but then later changed his mind on that issue to use it for himself. But even then, the trial court properly didn't even look further into that because our operative period was the 4 months prior to going to jail.
In the record, do we know why the father went back to jail about a month after being released?
It was because of a failed drug screen. He was on probation.
Okay. And then he stayed in jail for how long after that? You know?
It was 2020, early 2020, I believe.
Okay. So he went back to jail in July of 2019 and then was released not until January of 2020.
Yes, Your Honor.
What do you think gave the guardian ad litem pause about finding that termination was in the best interest of the children?
I think that she believes that the children should stay where they're at. I think that the guardian ad litem, rather than arguing a certain position, she just tossed that to the trial court to make the decision. I don't think that she wanted to give that argument. I guess she wanted rather the trial court to consider the evidence and the testimony and then the questions that she had for the witnesses as a whole, and then the trial court make that decision.
I noticed these, your clients got married in February of 2019. And then a month after the father was released from jail is when they filed a petition for termination and adoption. What was the reason for that timing to file it at that point?
And Your Honor, I didn't represent him at the trial court, but my understanding is they didn't know he was in jail because it looked like from the record there was a lot of attempts to try to locate him, because as a practitioner, I know that if the opposing party's in jail, that's going to be an easy service, but it looked like from the record they had a hard time of locating him and finding him, and they even did an order of publication. So I don't think that they knew that he was in jail.
At the time they filed the termination petition, they didn't know.
It didn't look like that from the record, Your Honor.
Okay. I don't have anything further.
Judge McGee, do you have anything?
No.
All right, thank you. Thank you, Ms. Looper. We'll hear from Mr. Brown on rebuttal. Brown?
I guess it helps if I unmute myself. To rebut a few of the things that Ms. Looper was talking about, the trial court failed to find clear and convincing evidence that there was abandonment for failure to visit. They talked about that. That was presented, and they failed to find by clear and convincing evidence. There was testimony in there that, especially from Mr. Brandenburg, the appellate in this case, that he had reached out several times. He had messaged Ms. Hammonds in this case to try to get some visitation. He was ignored by it. He had reached out and tried to do those things. Also, when they talk about that he said he didn't know where to send the money. Well, Ms. Hammonds had moved twice and never told him where she moved during this time. She had moved one time to Crossville. I think she had testified about that in the case, and then he also had testified about that. She had moved to Crossville, and he didn't know where she lived in Crossville. She had then moved from Crossville, Tennessee to Baxter, Tennessee, and never notified him of any of those moves. As far as that operative period, we would talk about that more as far as they were still married up until August that time. There was no support order down during that time. So that for 3/4 of that 4-month operative period, they were still married. There was no obligation to support at that point.
Were they living together, Mr. Brown?
They were not together, no.
Okay.
So, Mr. Brown, you're saying there's no obligation for the parent to support the child if he's not living with the mother?
As far as him willfully non-paying, I don't think that he either knew that there was no order down that he knew to pay. And I don't know if there was any conversation between them or not, but there was nothing on the record to show that he knew that he should be paying anything at that point.
When did they separate, Mr. Brown?
I'm not sure, Your Honor.
But it was before the divorce was filed.
It was before the divorce was filed. And I think the divorce was filed on I'm not sure, Your Honor. I thought I had it wrote down here, but I do not.
Okay.
Up to the point of the trial, though, after that, the father has paid regularly since then. He got back on his feet. You know, I think he testified that he was going through a bad time during all this. He has worked regularly. He's paid support regularly since then. They talk about the May 20th accident. I think Ms. Looper brought that up. There was an incident on May 20th that both parties testified differently to. Mr. Bredenberg said nothing happened that day that would result in the nature that the appellee testified to. The court didn't find any facts, or I'm sorry, didn't have any findings of credibility in this. So it's just kind of a he said, she said thing. But they claim that was the last day that he visited. Mr. Bredenberg testified after that he had visited a few more times, that he didn't have the dates exactly, but it was in July. He provided pictures at the trial where he had been, pictures of him and one of the daughters where he had visited with a child after that May 20th date to kind of show that he had had visitation at that point. Ms. Looper alleged that, you know, that he wasn't bonded with the child, but I think it was testimony in the court at that time that they still called him daddy. I mean, I think that would show some kind of a bond. Ms. Looper mentioned some suicidal attempts. Those suicidal attempts was where he attempted to cut his wrist, but that was back in 2008, 2009. It wasn't anything relevant to this case. It was well before the children were in the picture and well before anything in this petition. He has also since completed probation. So any drug-related concerns that would be in there, he completed probation once he was released from that final term of jail. I think he had testified that he even paid extra on probation to try to get caught up and get off probation earlier at that point. As far as the best interest of the guardian ad litem, you know, she couldn't make that decision. I don't know what the holdup for her was, but she did say, I think it was her testimony, that it was close and that she couldn't say that it was in the best interest for the rights of the father to be terminated. I think Ms. Looper talked about some nightmares. She didn't go into much in that, but there was some testimony on the child having some nightmares, but there's no proof supported by any witness other than it was just the opinion of the mother that it might have something to do with the father. There was nothing that was saying she's having nightmares with the father. There was no medical proof, no expert proof put on that's why. It was just that she has nightmares every now and then, and the mother alluded that it may be because of the father. The tax return issue, it was actually the testimony of Mr. Brandenburg that he had gave it to his mother. I think his mother even testified that she had put it in her brother's account. They tried to pay that, and the stepmother, or not stepmother, but the grandchild's other mother would not accept it at that point. She would not give a receipt anyway, and that she didn't want to pay it without having a receipt.
I thank you. I think that's your time.
All right, thank you.
Any questions?
No, Your Honor.
All right, we'll give you a written opinion as soon as possible. Thank you very much for your argument today.
Thank you all.
This Honorable Court of Appeals stands adjourned.